Charter Communications is appealing a court ruling that said the ISP must face a lawsuit alleging the company falsely promised fast internet speeds that Charter knew it could not deliver. Charter claims that federal regulations, including the recent repeal of net neutrality rules, preempts the lawsuit filed by New York Attorney General Eric Schneiderman against Charter and its Time Warner Cable (TWC) subsidiary in February 2017. The New York Supreme Court rejected Charter's motion to dismiss the case on February 16, but Charter is appealing the decision in a state appellate court. Despite its name, the New York Supreme Court is not the state's highest court. Charter's appeal filed on Wednesday says the court erred as a matter of law in denying Charter's motion to dismiss the complaint's allegations regarding actual broadband speeds, because those claims directly conflict with the FCC's regime for measuring and disclosing broadband speeds and are therefore preempted. Charter still disputes Schneiderman's allegations that TWC's claims of speeds up to a certain Mbps were misleading. The up to speed promises are substantiated using the FCC's official methodology for defining and describing actual broadband speed and could not mislead a reasonable consumer, Charter wrote. In its appeal this week, Charter also claimed that the lawsuit's allegations regarding TWC's subjective representations about its network are just non-actionable puffery. Court rejected every argument made by Charter. By contrast, the state Supreme Court decision said that Charter can be held accountable for promising speeds up to a certain amount if there was no chance that customers could get those speeds. The ruling said, defendants' theory is contrary to New York law regarding up to claims. Spectrum TWC's argument that consumers should have expected to receive anything less than or equal to the advertised up to speeds has been rejected by the Court of Appeals where, as alleged here, the advertised up to speeds are functionally unattainable as a result of the defendant's knowing conduct. The state Supreme Court decision also said that Charter failed to identify any provision of the FCA Federal Communications Act that preempts state anti-fraud or consumer protection claims. Charter's claim that the net neutrality repeal order preempts the state lawsuit is contradicted by the FCC's own statement that the Commission will not disturb or displace the state's traditional role in generally policing such matters as fraud, taxation, and general commercial dealings, the court said. Charter's net neutrality repeal argument related to the FCC rules on network management disclosures rather than the rules on blocking and throttling. After winning the Supreme Court decision last month, Schneiderman noted that the court rejected every single argument made by Charter Spectrum in its attempts to block our lawsuit. This decision ensures that our office can continue to hold Charter Spectrum to account for its failure to deliver the reliable internet speeds it promised consumers, he said at the time. Among other things, Schneiderman's lawsuit accused TWC of providing customers with their older generation cable modems that couldn't produce the speeds customers paid for. The suit also accuses the company of manipulating speed tests conducted by the FCC in customers' homes. Disclosure: the Advance Newhouse Partnership, which owns 13% of Charter, is part of Advance Publications. Advance Publications owns Condé Nast, which owns Ars Technica.